views under Article 118 of the Constitution. My ladies, my lords, you are invited to look at the trial at the Senate, and you are told that it was time-bound. My ladies, my lords, it's a misconception and misreading of the Constitution under Article 147, 145. My ladies, my lords, the only time Senate was limited was when or if it constituted itself in a special committee. If what transpired in Parliament, in the Senate, was a matter that was under Article 145 clause 6, then we could say that the 10 days period mattered. But it is important for us and imperative for us, my ladies, my lords, to note that when the Senate starts to hear the impeachment of the Deputy President, it is such as a plenary of the House. And as such, the 10 days were not therefore applicable in that circumstances. Number two, my ladies, my lords, you've been told that the Deputy President avoided to appear for his defense and that he was represented. But my ladies, my lords, if my good learned friend Professor was carried with the truth, he would have drawn your attention to the provisions of the rules of procedure for the removal of the President and Deputy President, starting order number 78, 9, and you'd have drawn your attention to rule number 6. And on that rule number 6, he would have told you that the rule provides that where the President chooses to appear before the Senate, the President shall be required within 3 days of the invitation under sub rule 4 or rule 4 on the date specified in the invitation to file an answer to the charge with the office of the clerk of the Senate, in which the President shall set out. He would have told you the mode of appearance. 1, the President's response to the particulars of the allegations. Number B, how the President, and in this case the Deputy President, proposes to appear before the Senate. And that rule has created through mechanisms or through 3 ways in which the Deputy President would have appeared. 1, whether in person. 2, by advocate. 3, in person and by advocate. The operative word in our case, my ladies, my lords, is number 3, in person and by way of advocate. The Deputy President appeared in person and by advocate. And as such, my ladies, my lords, when he was taken ill, the question of then appearing in person and by advocate was an issue. And number 2, my ladies, my lords, he was a witness, and the only key witness before the Senate. How then could you say that there was fair trial under Article 50 of the Constitution when the only fundamental infrastructure of the trial is unavailable? My ladies, my lords, permit me to address you on what was submitted by Mr. Somane. It's unfortunate that he has chosen to have a very lean and thin way of looking at the application of Article 149 of the Constitution. There can never be anything that is misleading to say that that article should be read in isolation of other provisions of the Constitution. If you choose to read Article 149 in isolation, you arrive at the absurdity that Mr. Somane and his colleagues have arrived at. I would urge this honorable court to look at the import of Article 259 of the Constitution, which provides for the manner in which the Constitution must be interpreted. If Mr. Somane was carried with the truth, he would have invited this honorable court to harmonize and purposely read into Article 149. My ladies, my lords, the reading of Article 149 in a purposive and in a harmonious way would have told Mr. Somane that then Article 99 and Article 137 of the Constitution is imperative. And therefore to say that the IBC had no role in the process of the nomination of Mr. Kindiki is absurd, is not true. The fact is that if Mr. Kindiki was to successfully become the Deputy President of the Republic of Kenya Is it then true that he can become a deputy president who has not qualified under Article 99 of the Constitution? Is it therefore true that he can become the deputy president if he has not qualified under Article 137 of the Constitution? Who then determines this qualification? Is it the president? Is it Mr. Somane? Is it Ndegwa? Who determines that qualification if it is not the IBC?
My Lord, there is something that Mr. Njiru is submitting on, which touches on very critical parts concerning Professor Ragathi as to his qualifications. And we are all familiar with the qualifications of Professor Kindiki.
I think the last time Mr. Kamodo was before you, he said he has no client.
I have a client, the 10th respondent, the United Democratic Alliance. I ceased to work for the other client because it would have been illegal. But I have a client. So I'm properly on record. And it is important that the record be made straight with regard to Professor Kindiki's qualification and including what had been cited in the affidavit that he was not a member of the UDA for 3 months, which is not a requirement in law. No law requires you to be a member of a political party for 3 months for you to ascend to the position of the deputy president, which Professor Kindiki has acceded to. And secondly, if you
That's a great issue that is being raised. So we're going to have the opportunity to answer it, because the law is the opposite of what you say.
It was raised by Mr. Njiru. I'm just clarifying. Then
So
Mr.
trying
Njiru
to
will
raise
continue.
that issue, that is my submission, my law. He is going into the merits.
But then Mr. Njiru may
Just let's sort it. My Lord, it's views on record for Professor Kindiki. I think if Mr. Njiru, my very good friend, I usually call him the Black Bull, would keep off rehashing his application.
The black what?
Bull. That's what Njiru means. If my friend, the Black Bull, would keep within the remit of a rejoinder and a reply, will not be having all these interjections. I've been resisting that because I always try to avoid appearing cantankerous. But if he keeps rehashing his application, unfortunately, then as a person on record for Professor Kindiki, I will be forced to be cantankerous, which is not my nature.
Let's give Mr. Njiru time to.
I am most surprised, my lord. My lords, finally, let us distinguish the Kisi case from what is before you. What is before you, my ladies, my lords, is a case where a party was not granted an opportunity to be heard. It is a question where there is a violation of Article 27, violation of Article 10, violation of Article 50, and violation of Article 25, that the right to be heard cannot be derogated. What was in Kisi, my ladies, my lords, is that the Kisi deputy governor underwent the full trial.
Court looks, the court does not accept a situation in which one is, of course, these issues that you are saying, that is saying there is no comeback from impeachment and all this, and that we proceed and swear. My lord, if that were to be the case, then it would mean that impeachment is not the legitimate subject matter of this honorable court. Yet we have had the decisions that they have read themselves from the Supreme Court on the issues of impeachment. My lord, Mr. Modomi, I'm calling my friend, came with these interesting arguments that on the issues of jurisdiction. My lord, these issues of jurisdiction is an interesting one, as we see it in a minute. My lord, the first impeachment case that appeared before a three-judge bench was in Kerugoya. Kerugoya seems to favor a lot of impeachment stuff, and it related from the Embu cases. I don't know whether Professor Ugenda was there. It is important to say this with regards to that I actually made the precise argument that my learned friend Mr. Mubobi made about whether
Impeachment of the president, because my
Yes,
submission was not that impeachment is generally non-justiciable. Even the authority cited it was about the impeachment of the president, whether that is justiciable.
I'll come to that in a minute. But the point I want to make, for purposes of the argument, the authorities there, for purposes of the argument, those precise arguments were made. There is actually no distinction when you look at the impeachment for Governor under 181, how it is carried out in the release the one of the president. But for all the significant position that I wish to make from that case is this, that subsequent thereto, all courts from Court of Appeal to Supreme Court have taken the position that it was the desire of the Kenyan people that nothing shall be beyond the reach of the court for purposes of giving redress. And that is the basis upon which we have been proceeding. I will end it up there and come to what is more comfortable with. Jurisdiction with regard to purported ouster of the jurisdiction of this court with regard to impeachment of the president. My Lord, jurisdiction is actually not given in the manner that they are suggesting. My Lord, even for purposes of the governor, which he says is different, there is no provision under Article, I believe it's 181, that says, or 182, let me just confirm. Yes, my Lord, for purposes of the removal of county government under 181, the issue is, none of those procedures actually say that after you are done with impeachment, you will go to the high court.
As you do in Parliament. The impeachment
Professor, this is not Parliament. So, and he has not sought your help. Please sit down.
I know that tactic. But my Lord, the point I'm making is that even for purposes of Article 181 and 182 of the Constitution, there is nowhere that those provisions say that when you are done with impeachment at the Senate, you will go to the High Court. But nonetheless, people have been going to the High Court on account of jurisdiction as set out in Article 165 of the Constitution, the jurisdictions of the High Court. And therefore, my Lord, this requirement that, there is no provisions for going to court, it is neither here nor there. That is not the design of the Constitution. That question of jurisdiction has been settled by specific provisions of the Constitution. My Lord, what about these issues that you needed to go to the Supreme Court? My Lord, for purposes of the jurisdictions of the Supreme Court, it has been settled very clearly. I believe it is under Article 163, Article 3, and it is settled in a manner that it says in very, very conclusive terms. This is 163. I believe it is 2. It is actually 3 and 4. They completely settle what is within the jurisdiction of the Supreme Court. Their argument that you cannot arrogate jurisdiction would actually come into play in this particular manner if this court were to make a finding that this matter ought to go before the Supreme Court. Because effectively, you would be amending Article 163, 3 and 4 of the Constitution as to the jurisdiction of the Supreme Court. But my Lord, where you find comfort is that the jurisdictions of the High Court, and that's why it is a court of original civil and whatever and criminal jurisdiction, is that the High Court has jurisdictions in everything unless the Constitution says otherwise. And to deal with that, when we come to the Senate, the moment, my Lord, you say the Senate was sitting in a quasi-judicial capacity, it is a design of the Constitution that any person who sits in a quasi-judicial capacity, there is a right to go to the High Court. There is no law in this country, not one, in which any person who sits in a quasi-judicial capacity, there is no remedy to go to the High Court by way of appeal, by way of Article 23, or any other manner. So that issue of jurisdiction is neither here nor there from the plain reading of the Constitution itself. So the other cases of Nixon, all those, they would be neither here nor there.
Dr. Ogada also addressed this, but what is your view on the submissions by Dr. Kenkuli about the constitutional history of
yes.
that issue?
That's very interesting. I think I should say something. I was just giving myself additional pressure. My Lord, for purposes of that history, and incidentally, as a young lawyer, I was involved in all this process, that is CEO of Muite, Orengo, and Dr. Gibson Kamau Kuria, so I can speak in past knowledge of some of these issues. My Lord, this Bomas draft constitution, you actually find it very interesting. We cannot go deeply into it. My Lord, the issue that is important to note is that under the bond, the duty, the standing orders and in the Constitution, as a presiding officer in the National Assembly or in the Senate, the Speaker, there is a duty of impartiality. That is where anything you read about the Speaker, they talk about that. The duty of impartiality for purposes of the Speaker. For purposes of both Speakers, my Lord, they made the rules of impeachment. Those rules are the subject matter of what is going on. How you will carry out public participation, the calls that were made, is it going to be plenary, is it going to be committee? The most important one being, you could have held these proceedings until Sunday, you decided to read the rules, to allow people to vote on issue of rights. My Lord, my knowledge under Article 27 of the Constitution, matters of rights are not subjected to votes. Yet that is what happened at the Senate. So that's an issue that we shall be talking about when we come to the hearing of the petition. So the Speaker is not a nobody. The Speaker, for purposes of these proceedings, as they happen, all those speakers, they made consequential decisions that have had really serious implications in the matters that is before you. Mr. Bumbo, my learned colleague, he says very many useful things. You wonder what to choose, what to leave. One of the issues that he said that is when of Article 73(1) of the Constitution. That, of course, will be the case when he reaches the end of the road in these proceedings. End of the road will be Supreme Court, I am sure. But as of now, that issue does not arise. My Lord, as regards the issue of Article 148, 149, I think we have said a lot about it, except, my Lord, when it is alleged that public participation under Article 149 is not required. My Lord, the issue is this. The Constitution is clear that from Article 10, it says whenever you are interpreting or applying the law, the values and principles in Article 10, which includes public participation, shall apply. What that means, if the Parliament is carrying out a constitutional duty,
of the Constitution requiring public participation is deleted from the
I hope this information will serve its purpose.
I think you did answer Senator Council's question.
It's actually, that decision will actually reverberate through all cases that touch on public participation. It's earth-shattering, and we are happy that God has brought it at this time to us. So God is on our side.
But I wonder now whether it is who was talking about Roscoe Powell. Somebody was talking about Roscoe Powell. But I agree with Roscoe Powell, one of my favorite legal philosophers, when he talked